John, I like to joke with people that I got all of my legal training through watching Law and Order and Special Victim Units on television. It's really one of those things that the modern television has been able to capture something that we do on a daily basis and turn it into entertainment. One of the things I notice about that, though, is people are always being read their rights. They have the right to remain silent. What are the rights that service members enjoy in the military with respect to the right to remain silent?
Well, it's similar to the Miranda rights that we've all seen on the television shows. The Article 31 Bravo rights are your constitutional right against self-incrimination, but there are some nuanced differences between the rights that are afforded to you under Article 31B of the UCMJ and your standard regular Miranda rights.
Well, I understand that Miranda was a case that decided the Fifth Amendment, the right to remain silent, and that is that if you're under custodial interrogation, meaning you are in a position to where you cannot leave and you're being interrogated by law enforcement, then you must be given these rights prophylactically so that you know what you're waiving if you decide to talk. And those rights are like the right to remain silent, the right to counsel, and the right to stop questioning at any time. What are the Article 31B rights?
So some of the differences between your standard Miranda rights and your Article 31 Bravo rights are, first, you don't have to be the subject of custodial interrogation. Your Article 31 Bravo rights apply anywhere at any time in any space, essentially. You don't have to be under lock and key and being interrogated by law enforcement or your commander, essentially with you wherever you go.
Right, so Article 31B applies to anybody who's subject to the code. So me as a questioner, if I'm subject to the code, I'm required to give you your Article 31B rights before I ask you any questions. And those rights include, the right to remain silent, the right to cease questioning, and, I always would say the right to counsel, although I don't think in Article 31B it specifically mentions the right to counsel. But during the typical Army rights warning waivers, right to counsel is always mentioned. But you're right, custodial interrogation is not necessary, and the accused doesn't have to know about the facts or circumstances of the crime as they do under Article 31B. So soldiers have to be told what they're being investigated for. So what happens if there is a statement that's taken in violation of Article 31B?
Well, that statement is not allowed to be used at a court-martial, for sure. Now, it may be able to be used in certain types of administrative investigations, typically as a matter of practice. We usually do not use those unsworn statements or those statements that were taken in violation of Article 31 and use those against you in an administrative investigation, but sometimes they do.
Well, they're certainly inadmissible at a court-martial, except for the limited purposes of proving absence of mistake, proving consciousness of guilt, or impeaching somebody who's testifying contrary to that statement. Why should somebody seek the legal counsel of the law office of William Helixon if they've been advised of their rights under Article 31B?
Well, if they've been advised of their rights, then they're probably under investigation for something that may be very adverse to them, both in the near term and far term. So it's very advisable that you come and seek legal counsel, whether it's going to be with TDS or with us. The first thing you should do is seek legal counsel.
The bottom line is, do not give a statement without first seeking the advice of legal counsel. We are the law office of William Helixson. We are your warrior advocates. You defend the nation. We defend you.